Now in today's video, we're going to be talking about something, to be quite candid with you, that you might have already heard about, and that is the pistol brace rule. More specifically, an injunction that was handed down by a U.S. district judge in Texas that bars the ATF throughout the United States, interestingly enough, from enforcing the pistol brace rule. Now, first and foremost, what is the pistol brace rule? Many of you are probably all too aware that pistol braces were originally developed for AR-15 style pistols that would allow those with disabilities to be able to shoot them as they were intended to be shot. Now, because of the nature of the actual product, it is conceivable that somebody could take the product and rather than using it in the method that it was originally designed, they could use it as a stock. They could shoulder their AR pistol. This would, in that type of use case, suddenly transform the weapon from being a pistol to being a rifle. Now, for years, the ATF had looked at the pistol brace and saw it for exactly what it was. It was a tool that was designed for shooters that suffered from disabilities to be able to use the underlying product, the AR pistol, in a manner in which it was originally designed. Individuals improperly used the pistol brace to create what would effectively be an SBR. Now, like I said, ATF for a number of years looked at this and said it's a pistol brace. It's used for its intended purpose. We cannot regulate based on the idea that someone would improperly use this product in an illegal fashion. Anyways, ATF changed their position, not surprisingly, to now suddenly say that this once legal product that thousands of people own throughout the United States suddenly has turned into an illegal product and a substantially illegal product. If you were to be found with a pistol brace, you could be looking at upwards of 10 years imprisonment and a substantial fine. Anyways, a lawsuit was levied against the ATF, and it went before a judge in Amarillo, Texas. Anyways, the judge had to make a decision early on in the case as to whether or not an injunction should be levied. Now, whenever an injunction is asked for by a court has to undergo effectively a balancing test. And just to kind of like string this together so that you understand procedurally how this works, when a law has been promulgated that's being challenged, especially if it's being challenged on constitutional grounds, then typically the plaintiffs, us, will ask for a preliminary injunction. We understand that this law going through the court system is going to essentially be in effect until a judge renders a final decision. Well, that could last 2 years, and during that time, your rights are being potentially violated. Not potentially, your rights are being violated. So we use this method of a preliminary injunction, essentially saying, okay, judge, look, we're challenging the constitutional validity of this law. We want to have the enforcement of the law stayed until the conclusion of the trial. Now, if we lose at the end of the trial, then the law would go back into effect. If, on the other hand, we prevail, then at least for the preceding 2 years or so, as this court case was being litigated, our constitutional rights weren't being violated. Now, for a judge to issue a preliminary injunction, they have to go through a 4-factor test. Now, for us, the most important parts of these factors are the first 2 factors. Number 1, whether or not we have a high probability of prevailing on the merits in the final decision. The second level of analysis is whether or not we would suffer an irreparable harm if the law is continued to be enforced. Okay guys, I'm pausing this video for just a moment. USCCA, which sponsors these videos, is doing a giveaway. It's really cool and you're gonna wanna participate. You can read all about it in the descriptions below the video, but you're going to want to participate pretty quickly because it will end soon. All right, with that, let's get back to the video. So they usually start with the second question, the irreparable harm question, and the judge essentially will look at it and say, all right, if this law is enforced during the time that the trial is being conducted, what kind of harm are the plaintiffs going to suffer? In this case, it's a constitutional harm. Their constitutional rights are being abrogated. Well, that is per se irreparable harm. So they automatically satisfy the number 2 requirement. Then the court would look at the first question, whether or not there is a high likelihood of the plaintiffs actually prevailing at trial. And for this, a judge has to do a Bruin analysis. Now, I want to pause for a second because I want you to really think about this for a moment. No testimony has been given. No data has been developed, okay? There has been no witness testimony. A judge looking simply at the law and simply at the court test, in this case, the Bruin decision, has to effectively render a decision. Now, it is conceivable, extraordinarily unlikely, but it is conceivable that at the conclusion of the trial, the judge would come to an entirely different conclusion than he did when he issued or failed to issue the preliminary injunction. But it's rare. Usually when a judge issues a preliminary injunction, they are in fact telegraphing this is the way that the case is ultimately going to be decided. In fact, it usually means that the case is probably not going to survive summary judgment. In this particular case in Amarillo, Texas, the judge looked at the underlying statute, looked at Bruin, and in a 9-page decision essentially said, yeah, this is absolute crap, okay? Use of a product cannot be regulated by preventing people from owning the product. I mean, to paraphrase the judge and to come up with an entirely different analogy, a hammer is designed for a purpose of nailing nails into a piece of wood or into some sort of substrate, right? A hammer could also be misused as a tool to hurt someone. You cannot make hammers illegal because someone would misuse that product. Now, many of you have probably heard this analogy before. This goes to a tremendous level, all of the different types of gun control regulations that currently exist out there. You know, you've got millions of law-abiding gun owners who do not misuse their products, but the government would seek to restrict our ability to own these products because a subset of criminals misuse the products. In any event, the judge has issued his preliminary injunction. ATF has been banned. And interestingly enough, and I'm not entirely sure that it procedurally works, but it bans it nationwide. Now, typically, a judge really only has the empowerment to be able to control what takes place within their circuit. This one is more expansive than that. Now, having said all that, we already know that the state is going to appeal the injunction, and we'll have to ultimately see what happens. But for right now, at the moment, the law has been precluded from being enforced. So, rock and roll, I guess, with your pistol braces. We will, like I said, have to see what ultimately happens with this, although, as I've mentioned in previous videos, one of the major components associated with this case is tremendous executive overreach by the ATF in coming up with rulemaking. There is no congressional legislation on pistol braces. And for an executive agency to create a rule that essentially says these things being simply in possession now create felonies with serious jail time attached to that, would seem to completely abrogate the constitutional protections that we have. Laws are supposed to be generated from the legislature, not from unelected bureaucrats in an executive agency. In any event, we'll have to see how this ultimately plays itself out. If we do get an overturning by the Supreme Court, on Chevron deference, which I think we're probably going to get this term, then to a large extent this might ultimately be moot. And of course, we still do have actually at least 2 Supreme Court decisions that we'll be getting opinions on at the end of next year, well, actually in June of next year, that might actually help tailor in some of these Second Amendment jurisprudential questions. As always, if you would like to email me, please do at Stephen@artemishq.com. And as always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.
Before you go, you just missed one of our best videos that got over 500,000 views. Click right here to watch it now.